Good afternoon, my name is Ronaldo Hilton, the Chairperson Designee of the New York City Loft Board. Welcome to our January 16th, 2020 public meeting. A Happy New Year to everyone. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversion of multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residencies that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board rules. We first turn our attention to vote of the minutes from the November 21st, 2019 meeting. Are there any corrections or comments to the minutes?
Yes, I have a couple.
Mr. Delaney?
On page 3, we talk about, there's a discussion about the website.
Yes.
And I gather there's positive news.
Yes.
It's the January 16th meeting?
The November 21st minutes.
Excuse me.
Oh, okay, go ahead. That's
So,
yeah, we're about to do that, but it may not be so popular.
all right. And on page 5 of the November 21st minutes, we discussed Ms. Torres Moskowitz's expression of interest in self-certification.
Yes.
Has there been any progress on that?
On that, we have I've taken that request to I don't want to call names, but yeah, I've taken it up, and I'm still waiting on some scheduling of that, yeah. But I don't have any concrete response to give.
Okay. On page 7, in the discussion of 110 Bridge Street, there's a typo in the minutes from the second paragraph where my comments are summarized. With regard to a unit where a married couple was found, that one of them is covered because that's the individual who signed the lease and the other is not covered. So the last sentence there currently reads, so I know my objection to that part of the decision, but I plan to vote in favor of the order. It should be, so I note my objection.
Thank
that part of the
Yes,
decision.
makes sense, yes, thank you.
And that's all.
Are there any other comments or corrections? Thank you, Mr. Delaney. Ms. Rivera? No. A motion, I'm sorry. A motion to accept minutes.
I'll move.
Mr. Delaney, a second. Ms. Torres. Ms. Rivera.
Mr. Barber.
Yes.
Mr. Roach.
Yes.
Mr. Delaney.
Yes.
Ms. Grossman. Yes. Mr. Torres.
Yes.
Chairperson Hilton.
Yes.
6 in favor, 2 absent.
Thank you, Ms. Rivera. The next is a vote on the minutes of the December 5th meeting. Are there any corrections or comments to those minutes? Yes. Mr. Delaney.
It would appear, reading these minutes, that the attendees list is incorrect because at some point during the meeting, Mr. Hernandez is quoted as making comments, but he's not listed as being present because, as I recall, he came late to the meeting.
Yes, he was. Yes.
So I think the minutes should be modified to reflect that he was an attendee.
Okay. True. Happened. Okay, we'll do that.
And on page 27, you know what, we can leave that. It's okay.
Okay. Are there any other comments or corrections noted? Okay, do we have a motion then to accept these minutes? Mr. Barnes, second. Ms. Torres. Ms. Rivera, could you please poll the board members?
Mr. Byron.
Yes.
Mr. Roach.
Yes.
Mr. Delaney.
Yes.
Ms. Rosen. Abstain. Ms. Torres.
Yes.
Chairperson Henson.
Yes.
5 in favor, 1 abstain, 2 absent.
Thank you. Okay, so just so I mentioned before, we do have a presentation on the new website that Loft Board, the farm buildings have put together for the Loft Board, but we're having technical difficulties now with internet connection, so they've gone to fix that. So we're going to move on to the Executive Director's report. Yes.
Just on that, do we expect that this is going to go live soon?
Yes, sir.
Yeah.
Yeah.
We won't wait for a presentation.
No, well, we want, as a courtesy, I want us to see it before we do, so. Yeah, so Ms. Balsam will now give her Executive Director's report.
Thank you. So in terms of staffing, our new Deputy General Counsel will be starting before the end of the month. And we've identified a candidate for the Assistant General Counsel position, and so that paperwork is in process. I also, did we leave? Oh. Okay, I also wanted to introduce our new HPD inspector, Curtis Lewis. So for those of you in the Loft community, if you're making complaints, this is who is going to be responding. Inspector Lewis, he has many years with HPD, and I think it's going to be great. Okay, in terms of revenue, we collected $139,922 in November and $61,595 in December. As of today, we have 330 buildings in our jurisdiction. I gave you a chart which had a breakdown. I'm sorry it wasn't as specific as some of the charts that we've had in the past, but this is all I could come up with because we have so much to do and so few people. So the chart has the different milestone categories, how many buildings are within that category, and then the breakdown by the different window periods. So as you can see, interestingly enough, we still have the most buildings from the first window period, but they are finally, I think, starting to move. And we're getting there slowly for some of the buildings. Snails as opposed to road runners, but we're at least moving forward. So that's that for those statistics. In litigation, I sent the board, and you have hard copies here, of a couple of decisions that came down in cases where we were sued by 99 Sutton. So in the first case, the owner challenged the board decision which denied owner's request for removal from the jurisdiction and invalidated sales of rights. The court found the challenge to the denial of the removal application was a non-final order, so it wasn't subject to review in the proceeding. As to the board's rejection of the sales of rights, the court rejected the owner's arguments and found owner failed to rebut the board's findings or cast doubt on the board's conclusion that staff had a rational basis when it issued the determination rejecting all of the sales. So it's a very interesting decision. It's very clearly written, and I think it'll provide us good guidance as we do rulemaking, and hopefully we'll work on that rule later today. And the other case is one of the mandamus cases. There are several of them outstanding, and so the owner wanted us to very quickly review their sales of rights before other people who had filed before them, and the court dismissed the petition, finding that we had proceeded in good faith in deciding their applications. We have one new case, 475 Kent Owners versus New York City Loft Board, where the owner is requesting an order of mandamus to compel the Loft Board to decide 4 separate coverage applications that are pending. They've come back from oath. And that's pretty much it.
How old are those cases?
Well, we usually do it by the filing date, but they came back in 2018. So, I mean, we're getting to them. They're making their way up the list, but some of the cases that we have on the list today are much older.
Question, you reported that there's a new deputy general counsel
She hasn't started yet. She'll be starting before the end of the month.
who will be starting by the end of the month.
Yes,
Is
she should be at the next meeting.
Does she have a name?
I don't want to really, unless that person has started that one.
Oh,
Say that
okay,
first.
all right.
Unless, until the person's an employee, we wouldn't want to release them.
I see.
Okay,
Is that-
anything else?
No.
Okay.
Thank you, Ms. Bawson. So we then, just before, I did clarify that Adaku is coming back to do the presentation. With your permission, if we're in the case, we're discussing the case, we'll, at the end of that one, we'll just interrupt and let her, because let her do a presentation before we go in, because she's got other things going. All right, so we then turn to vote on the cases. First is the appeal and reconsideration calendar. There is one case on the appeal and reconsideration calendar, and that case is FJH Realty Inc. at 79 Lorimer Street in Brooklyn, docket number AD0097. Ms. Lee will present this case.
Thank you, Chairperson Hilton. This proposed order concerns the administrative appeal application of FJH Realty Inc., the owner of the building located at 79 Lorimer Street in Brooklyn, New York. In December of 2017, the owner filed an extension application requesting an extension of the code compliance deadlines provided in MDL Section 2841VI. In April of 2018, the executive director issued an administrative determination denying the extension application and finding that even though the owner had timely filed the application, the owner had failed to demonstrate good faith efforts toward legalizing the building. This proposed order agrees with the administrative determination for the following reasons. Appeals from determinations made by the law board staff are governed by the law board's rules as set forth in 29 RCNY Section 1-07.1. In its appeal, the owner provided several documents which were not initially submitted with its extension application. Pursuant to 29 RCNY Section 1-07.11D, this proposed order declines to consider the additional documents that were submitted in the appeal, as the owner has failed to demonstrate good cause as to why the additional documents were not previously submitted with its extension application. In its appeal, the owner also makes 4 arguments concerning errors of law. This proposed order finds that the executive director made no error or misinterpretation of law. First, the owner argues that occurrences prior to coverage may not serve as a basis for denying an extension. Because the owner has failed to establish that it has made good faith efforts to meet code compliance deadlines even after the date of coverage, we do not need to consider this issue at this time. Next, the owner argues that mistakes in registration do not constitute a basis for denial of an extension application, and that the executive director should only focus on an owner's good faith actions toward legalization in deciding the application. This proposed order disagrees, as registration of the building with the law board is part of the legalization process. IND owners must submit accurate registration information when such information is required by the law board's rules or is required requested by the law board staff. Providing accurate registration information allows the law board staff to give proper notice to the affected parties. Additionally, unresolved errors in registration may result in discrepancies between records, creating confusion and delays in the later stages of the legalization process. In its third argument, the owner contends that it made good faith efforts to comply with the legalization requirements of Article 7C and the law board's rules from the date of the law board's coverage determination through the filing of its extension application. The owner also contends that it had no obligation to take any action to restore the tenants to occupancy prior to a coverage determination. The owner further asserts that neither the loft law nor its regulations state a single standard by which good faith actions are to be measured, and therefore its efforts to lift a vacate order and to begin the legalization process by interviewing architects constitute good faith efforts. This proposed order agrees that there is no obligation to legalize a dwelling prior to a coverage determination. However, the owner has failed to demonstrate good faith efforts to meet code compliance deadlines even after the Loft Board's finding of coverage. As to the standard by which good faith efforts are to be determined or measured, it has evolved via Loft Board case law, and the owner's actions here do not meet the standard. Finally, the owner asserts that the administrative determination disregards the remedial nature of the loft law. This proposed order disagrees. The executive director is bound by the rules of the Loft Board, and the plain language of the rules states that the executive director may only grant an extension of the code compliance deadlines where an IMD owner has demonstrated that it has met the statutory standards for an extension. Based on the foregoing, this proposed order denies the owner's appeal.
Thank you, Ms. Lee. Is there a motion to accept this case? Mr. Delaney, is there a second?
Second.
Mr. Roche. Any comments?
I think it's very clear and very well written.
Thank you. Any other comments? Ms. Rivera, could you please poll the board members?
Mr. Barrett,
Yes.
Mr. Roach,
Yes.
Mr. Delaney,
Yes.
Ms. Grossman,
Yes.
Ms. Torres,
Yes.
Chairperson Hudson.
Yes.
6 in favor, 2 absent.
There are 2 cases on the summary calendar. They're voted on as a group, and these cases are Christina Manis, 54 Knickerbocker Avenue in Brooklyn, docket number TA0258, and the second is Jeff Larvia et al. And others, 223 15th Street in Brooklyn. That docket number is TR1244. Do we have a motion to accept these cases? Mr. Delaney, there's second. Mr. Bartlett. Thank you. Ms. Rivera, could you please? Comments, I'm sorry.
I'm sorry, I do have a comment on case number 3, 223 15th Street in Brooklyn. This case was tentatively scheduled for November and was tabled at that time. And the revised order that we have before us today is a significant improvement. What happened in this case is that it's a 4-unit building. 3 of the applicants had, either during the pendency of the case or before, had sold their rights under 286-12. And last November, the Loft Board was on the verge of making this a 1-unit interim multiple dwelling, which would have allowed the owner to rent the other 3 units at market rent and not be under the necessity of legalizing the units under the Loft Board's supervision. The order before us today orders the owner to register all 4 units as IMD dwellings and to legalize all 4 of those units. This is an important step to make sure that the board sees to it that units that qualify for coverage do in fact get registered rather than allow the owner to evade the corrective purpose of the loft law by purchasing a sale of rights. It also avoids the conundrum of saying, well, you sold your rights under the loft law, but you weren't covered under the loft law, so how could it be a valid sale of rights? So these are IMD units, and they will be legalized with the Loft Board's oversight, and that's a good thing.
Thank you, Mr. Delaney. Are there any other comments? Ms. Rivera, could you please poll the board members?
Mr. Barrett,
Yes.
Mr. Roach,
Yes.
Mr. Delaney,
Yes.
Ms. Grossman,
Yes.
Ms. Torres,
Yes.
Chairperson Hudson.
Yes.
6 in favor, 2 absent.
There is another case that no one comes, right? So that vote goes for these 2 cases, yes? Good. All right. There are 6 proposed orders on the master calendar. And the first case is 99 Sutton LLC at 99 Sutton Street in Brooklyn. That docket number is FO0826, and Ms. Lee will present this case.
Thank you, Chairperson Hilton. This proposed order concerns the renewal of the annual registration for the building located at 99 Sutton Street in Brooklyn, New York. In November of 2019, the Loft Board staff sent a notice to the owner of the building alleging that the owner had failed to file the annual registration form and to pay the applicable registration fees as well as late fees for fiscal years 2018, 2019, and 2020. The Loft Board staff also asserted that the owner had failed to pay a fine that was imposed by Loft Board Order number 4720 and a separate fine that was imposed by Loft Board Order number 4656. Upon receipt and review of the owner's answer contesting the proceeding, and upon further investigation conducted by the Loft Board staff, this proposed order finds that the owner has already filed the annual registration form and has paid the annual registration fee along with associated late fees for fiscal year 2018. The owner has also timely filed the annual registration form and has paid the annual registration fee for fiscal year 2019. In addition, owner has already paid the fine imposed by Loft Board Order number 4720. Moreover, the fine imposed by Loft Board Order number 4656 was previously rescinded by Loft Board Order number 4852. However, the owner has not yet renewed its annual registration for fiscal year 2020. Therefore, the annual registration fee and the late fees associated with fiscal year 2020 remain applicable and continue to accrue until owner completes its annual registration. Because the owner has failed to timely complete its annual registration for 1 year, this proposed order imposes an additional fine of $5,000 against the owner pursuant to 29 RCNY Section 2-11.1B3.
Thank you, Ms. Lee. We're working her hard, right? Do we have a motion to accept this case? Good, Ms. Roslin. Second? Second. Okay, Ms. Torres. Are there any comments? No comments? Mr. Rivera, could you please poll the board members?
Ms. Byron?
Yes.
Mr. Roach?
Yes.
Mr. Delaney?
Yes.
Ms. Grossman?
Yes.
Ms. Torres?
Yes.
Chairperson Hilton?
Yes.
6 in favor, 2 absent.
The next case is tenants of 85 North 6th Street at 85 North 6th Street in Brooklyn. 3 docket numbers are PO0013, PO0015, and TR1103. Ms. Lee will again present this case.
This proposed order concerns a coverage application and 2 protected occupancy applications that were filed for 4 units at the building located at 85 North 6th Street in Brooklyn, New York. By a memorandum decision dated May 1st, 2015, a motion to amend the coverage application to include the occupants of Units 2A and 2C as applicants, as well as to include the occupants of Unit 2A as protected occupants, and a motion to consolidate the protected occupancy applications for Units 2B and 2C with the pending coverage application as amended were granted. A 5-day hearing was subsequently held, and in November of 2015, Administrative Law Judge Alessandra Zorniati issued a report and recommendation in which she recommended that the premises be covered as an IMD building pursuant to MDL Section 281.5 with 4 units, and that the occupants of those units be granted Article 7C protection. The 2 coverage issues that were contested by the parties were as follows: whether Units 2B and 2C each have at least 1 window that opens onto a street, a lawful court, or a lawful yard as required under the loft law, and whether Units 2A, 2B, and 2C were residentially occupied for 12 consecutive months during the period commencing January 1st, 2008 and ending December 31st, 2009, which is hereinafter referred to as the window period. As to the first issue, on June 25, 2019, the New York State Legislature amended the loft law, eliminating the requirement that a unit needed a window in order to be eligible for coverage under MDL Section 281.5. Because the lack of a window is no longer a bar to coverage, we do not need to consider the merits of the arguments pertaining to the windows in Units 2B and 2C. As to the second issue, this proposed order finds that the record contains sufficient and credible testimonial and documentary evidence to conclude that Units 2A, 2B, 2C, and 3 were residentially occupied for 12 consecutive months during the window period, making all 4 units eligible for coverage under MDL Section 281.5. With respect to the protected occupancy claims, Protected occupancy determinations under the loft law are governed by 29 RCNY Section 2-09B. This proposed order finds that Ms. Dutra and Mr. Carlson have successfully established that they are prime lessees who use Unit 2A as their primary residence. Therefore, Ms. Dutra and Mr. Carlson are protected occupants pursuant to 29 RCNY Section 2-09B4. As to Unit 2B, this proposed order finds that Mr. Manriquez and Ms. Tandiono are the protected occupants of their unit under 29 RCNY Section 2-09B3 because they took possession of Unit 2B subsequent to the effective date of the 2010 amendments to the loft law, and they are prime lessees whose lease was in effect at the time of the filing of their protected occupancy application. As to Unit 2C, this proposed order finds that Mr. Sneed is a protected occupant of his unit under 29 RCNY Section 2-09B4 because he has successfully established that he is a prime lessee who uses Unit 2C as his primary residence. Finally, as to Unit 3, this proposed order finds that Ms. Evinger is a protected occupant of her unit under 29 RCNY Section 2-09B4 because she has also successfully established that she is a prime lessee who uses Unit 3 as her primary residence. However, Ms. Evinger's husband, Mr. Degoda, is not a protected occupant because there is no testimonial or documentary evidence to show that Mr. Degoda is a prime lessee or that written consent was provided by the landlord for him to occupy Unit 3. Given that Ms. Evinger is a protected occupant of Unit 3 to the exclusion of all other persons in possession of the unit, this proposed order finds that Mr. Degoda is not entitled to Article 7C protection. However, he may have succession rights. In sum, this proposed order grants the application for coverage. It finds that the building is an IMD building pursuant to MDL Section 280.15, that Units 2A, 2B, 2C, and 3 are IMD units, and that the occupants of those units are entitled to Article 7C protection except for Mr. Degoda.
Thank you, Ms. Lee. Do we have a motion to accept this case? Mr. Browds, is there a second? Mr. Roche. Then do we have any comments? Mr. Delaney?
Yes, yet again, we have a case where, in this case, Mr. Degoda moved into the unit in 2001 and married Ms. Evinger in July 2010, 10 years ago, 1 month after the loft law passed. In my opinion, Judge Zornati properly found both Ms. Evinger, Frauke Evinger and Mr. Degoda to be protected occupants. The loft board continues to take the position that whoever signed the lease is the protected occupant if there is a lease, and that the spouse, no matter for what period of time or how involved the spouse was in the creation of the loft, is not a protected occupant, but, quote, may have the rights to succession. This is something we're looking at in our rules. I plan to vote for this order despite taking issue with this one point, which I will note in an opinion, but this really can't continue, and in fact, under the draft rules that we will hopefully adopt sometime in 2020, it would change that. But I still believe that the loft board's analysis on this and many other protected occupant issues is wrong. It started to deviate in 2014 from what had been the practice of the loft board for all the years since it was formed in 1982. So I'll just note that for the record.
Thank you, Mr. Delaney. Do we have any more comments on this case? Mr. Rivera?
Mr. Flower?
Yes.
Mr. Roach?
Yes.
Mrs. Delaney?
Yes.
Ms. Roseman?
I recuse myself.
Mrs. Torres?
Yes.
Mr. Hilton Henson?
Yes.
5 in favor, 1 recused, 2 absent.
Thank you. The next case on the master calendar is tenants of 538 Johnson Avenue, also known as 75 Stewart Avenue, at 538 Johnson Avenue, Brooklyn. Those docket numbers are TR 1042, TR 1065, TR 1260, TR 1304, and TR 1346. Mr. Clark will present this case.
Thank you, Chairperson Hilton. This proposed order addresses several coverage applications filed pursuant to MDL 2815 and several protected occupant claims for the building located at 538 Johnson Avenue, aka 75 Stewart Avenue. It also addresses an answer filed by Whitney Lynch seeking coverage of Unit 207. On March 11, 2014, after some of the applications were filed and docketed, the owner of the building submitted a registration application. However, the Loft Board staff deemed the registration application incomplete. On April 15, 2016, owner filed a motion to vacate his default for failure to file an answer to some of the applications. In a memorandum dated June 1, 2016, the administrative law judge granted the motion to vacate, but also found owner did not timely contest the registration application pursuant to 29 RCNY 2-05B4 and therefore waived its right to do so. The parties filed a motion concerning whether or not the 538 Johnson Avenue structure and the 75 Stewart Avenue structure should be considered one building for coverage purposes. In a memorandum dated July 26, 2017, the judge granted owner's motion and found the two structures are considered one building for coverage purposes. Owner then filed another motion arguing the metal coating business on the first floor of 538 Johnson was an inherently incompatible commercial use that precluded coverage of the building. In an email dated February 6, 2018, the judge granted owner's motion as a matter of law pursuant to 29 RCNY section 2-08 KI. The judge then conducted a trial to determine whether the inherently incompatible commercial use continued at the time of submission of the coverage application and is actively and currently pursued pursuant to MDL 2815 and 29 RCNY section 2-08K. In a report dated February 5, 2019, the judge found the use continued at the time of submission of the coverage application and is actively and currently pursued, and therefore the coverage application should be denied. For the board to make a coverage determination today, the board must first determine whether the two buildings are considered one pursuant to the horizontal multiple dwelling doctrine. Second, whether there is inherently incompatible commercial use in the building. Third, whether the building and units meet the additional requirements pursuant to MDL 2815. And fourth, whether the tenants qualify for protected occupancy pursuant to 29 RCNY 2-09B. First, the two buildings are a horizontal multiple dwelling and considered one building for coverage purposes, based on the factors listed in 29 RCNY section 2-08 A1 III. Among other things, the two structures are contiguous. They share billing accounts and have combined Department of Buildings property profiles. Second, there is no inherently incompatible commercial use. Owner argues the metal coating operation falls within use group 17 or 18. However, in 2019, the legislature amended the Loft law and changed the exclusion relating to inherently incompatible use to apply only to uses in use group 18. The metal coating operation in the building includes cleaning, painting, and curing the metal. This does not fall within the examples of uses under use group 18 stated in New York City zoning resolution section 42-15. Even if it did, which it does not, the uses in use group 18 may only legally exist in the M3 zoning district, and the building is located in the M1, M2 zoning district. As to the third and fourth requirements, further adjudication is required to determine whether the building and the units listed in the applications meet the additional requirements for coverage and to determine protected occupancy. In the memorandum dated June 16, 2016, the judge found the owner waived his right to contest the registration application. However, the application was deemed incomplete by the Loft Board staff. The record does not contain sufficient evidence to determine coverage and protected occupancy. As to Ms. Lynch's coverage claim, Ms. Lynch submitted an answer rather than a coverage application, and therefore the issue is not properly before the board pursuant to 29 RCNY section 1-06A1 and A3. Therefore, the proposed order before you today finds the building is a horizontal multiple dwelling with no inherently incompatible commercial use and remands the applications back to Oath for further adjudication.
Thank you, Mr. Clark. Do we have a motion to accept this case? Mr. Delaney, is there a second? Mr. Barwitz, do we have any discussion, comments on this case?
Yes, I'm sorry to say.
It's such a complicated.
Can we get a heat inspector in here?
Yeah. We have an HPD inspector back there. He's down multiple dwelling, goes through no problem.
Fortunately, I guess, in this case, the circumstances are such that there weren't an inordinate number of days of trial on the incompatible use issue. We had a building before us that's now covered that had 20 days or something on the incompatible use issue. Here, the tenants would have lost on the incompatible use issue but for the legislature changing its position on incompatible use and limiting it to use group 18. So the coverage application filed by the tenants goes back to Oath for what I would fear in most circumstances would be a lengthy discussion of every single unit and whether or not that unit is being used as a primary residence and a protected occupant, and if you got married, or you, all that stuff that I was talking about before. However, the owner, realizing that his gambit was not going to succeed, has run in and registered under the new section of the law, 281.6. Very clever on the part of the owner, because that would, if that were found to be the provision of the law under which the owner's registration was accepted, that would result in the rents being, the established rents for the IMDs would be the 2019 rents, rather than the 2010 rents that will apply when the building's found to be covered under 281.5. Fortunately, the owner, when the owner filed for to register the building under 281.6, the owner also listed a lot of people as protected occupants, and hopefully that information can be presented to Judge Spooner to limit the number of days and the number of billable hours that attorneys will expend in haggling over who is a protected occupant, which used to be so simple for the first 2 decades or 2.5 decades of the loft law's existence, and has become so muddied now. So fortunately, hopefully, the owner's gambit will result in the tenants being covered under 281.5, but the owner's registration information will limit the amount of time that will be expended on sorting out who is a protected occupant.
Thank you, Mr. Delaney. Are there any other comments? Ms. Rivera?
Mr. Bowers?
Yes.
Mr. Roach?
Yes.
Mr. Delaney?
Yes.
Ms. Grossman?
Yes.
Ms. Torres?
Yes.
Chairperson Hudson?
Yes.
6 in favor, 2 absent.
Thank you, Mr. Clark. So the final 3 cases on the master calendar are removal cases, and they're voted on as a group. They are Triad Capital LLC, 15 East 17th Street in Manhattan. Those docket numbers are LE0583 and docket number LE0702. Then again, number 8, Triad Capital LLC, 13 East 17th Street in Manhattan. And those docket numbers are LE0584 and LE0703. Finally, 73 Washington LLC at 73 Washington Avenue in Brooklyn. That docket number is LE0673. Do we have a motion to accept these cases? Mr. Barwitz, is there a second? Someone? Mr. Delaney. Do we have any comments on these cases?
I think the people in the audience who have sat through almost an hour of this should at least be advised that cases 7 and 8, 15 East 17th Street and 13 East 17th Street, both involve cases where units are found to be covered even though the original occupant is no longer present, and we are setting a rent based on the legalization, which took quite a while, that results in probably a legal rent, which is significantly under what may currently be being paid by the occupant of that space. And this owner did some interesting things, and so the tenants, all the units in this building, in these two buildings that are side by side, but not a horizontal multiple dwelling, have the benefit of choosing between a 1-year or 2-year first lease, but the owner is not entitled to any rent increases for that period because the owner failed to make a proper filing. And so there are very interesting cases from a technical standpoint. The board spent quite a bit of time discussing them in the private session.
Thanks, Mr. Dillier. We can always count on you to summarize. Any other comments? Mr. Rivera.
Mr. Bauer.
Yes.
Mr. Rowe.
Yes.
Mr. Delaney.
Yes.
Ms. Grossman.
Yes.
Ms. Torres.
Yes.
Chairperson Hilton.
Yes.
6 in favor, 2 absent.
Thank you, Mr. Rivera. We're going to take a short break, and then we will resume either with rules or presentation. Not sure, but we'll take a short break. Okay, we're back in the record. We're now going to continue our discussion on the proposed rule changes, and Ms. Balsam will lead this discussion.
Okay, so I sent the board a new package that incorporated all of the revisions that we have decided on so far, except for the ones that we talked about for 210, because I wasn't sure what we were going to agree on for that, and we had said we were going to start with that today. So that proposed rule is on page 191. And this is the rule regarding sales of rights. Oh, and the other thing I should mention is we had a whole discussion where I wanted to make references to board or to staff in the rules, and I deleted all of those because I realized that we were not changing other rules and it would just cause more confusion, so everything's back to the loft board now. So if you see anything in there where I didn't change it back, please let me know. So now we're on sales of rights. I think this is a very important rule. We've had a lot of issues, the board has seen a lot of issues over the past few years regarding sales of rights. And so we're proposing, staff is proposing more than just ministerial changes, but some of these are ministerial. So the first ones, this begins on page 191 of your books, and we did have copies for the public if you wanted to look. I don't know if you took them, but we do have some copies if you want to look at them. So the first thing is no sales. We're adding references to 281.6. So on the bottom of page 191, no sale or agreement on line 18 made prior to the following dates in which an occupant purported to waive rights under Article 7C will be given any force or effect. And then on line 25, June 25, 2019, that should be 4 FOR units covered under 281.5 or 281.6 that became subject to Article 7C pursuant to Chapter 41 of the laws of 2019, and the rest of that sentence is being deleted. Any questions on that? That's just a reference to 281.6. Okay, so then on page 192, on line 5, I'm adding the number 1 for sales of rights pursuant to Article 7C, pursuant to, and we're adding MDL 286. which occur, or a sale of rights, which occurs on or after, and that date in there is going to be the effective date of the rule. They have 30 days to file the sale with the loft board. And then we're adding a second section. The owner or authorized representative must include documentation supporting the sale. Supporting documentation should include a fully executed sales agreement and proof of payment of the sales price, if applicable. The sales agreement must include a full description of the consideration, including the amount of monetary compensation, if any, supporting the sale. Now, previously, we never had a rule that said they were allowed to redact the sales price. We did, in the instruction form for the sales form, have something that said that the owners were allowed to redact the sales price. We deleted that instruction when it appeared that some of the sales really were nominal sales, that there wasn't valid consideration, or that there were issues. So we deleted those instructions, but some of the owners are still redacting the amount of the consideration. So from a policy perspective, I could understand why they would want to do that, because somebody might want to jack up a price for another unit. But on the other hand, I think that the board has an obligation to make sure that they're valid sales. And a $10 sale, I'm not sure is really a valid sale. So, and we have some case law on that also. So the only way to compel people to actually tell us how much the money is, assuming that it is money, because it could be not money, it could be you get to live in another unit rent-free for 5 years or something like that.
Is that what you mean by if applicable?
If applicable, yeah.
Okay.
Because it could be something other than
Okay.
money. It
So
doesn't
do you have
necessarily
to, do they have to say what their consideration was?
Yes,
Okay.
right, a full description of the consideration, including the amount of monetary compensation, if any. So the only way to compel people to do that is to have a rule that says it. My personal opinion, given what we've seen over the past couple of years, is it's important to keep it in there. To include this in there, if the board feels otherwise, that's fine, they're your rules. But I think it's important.
I think you don't need the comma on line 16.
Okay. Supporting documentation should include, yes, you are correct. That should be the least, that's the least.
I know, but it's
But yes, I
throwing up
agree,
because
yes.
It doesn't read
Yeah.
right.
Yeah,
We have all the right.
yeah.
As you know, I'm supportive of this approach. My question is, this says the sales agreement must include, but what is the or else? I mean, I think what you're really saying is to be accepted, it must include. Is it?
Well, the next line says, staff must reject any sale of rights that does not include a full statement of consideration supporting the sale. So that's the or else.
Well, were we using that Loftport, is it supposed to say Loftport now stuff? Or-
Oh, yes, it should say local. Thank you. That's what I missed.
So it's the loft board?
Yeah. And then the other thing that I threw in there, because we've had several questions about this, that the refund of the security deposit or a portion thereof is not, it should read, is not consideration for a sale. Because
Changing
people
that
may,
to not.
yeah, we actually had discussed that last time. Is not consideration for a sale. So,
You have not consideration to support a sale. It says not
not
consideration.
consideration for a sale. That was what we had talked about last time. Because people might be entitled to security deposit refunds anyway, so, legally they would be entitled to it. Not necessarily, but they could be, so how could that support a sale? That sale's supposed to be something
Can I
about
just say
that.
it's not acceptable consideration?
Okay. Everybody else okay with
It's
that?
not acceptable.
Acceptable consideration?
On line 20, staff must reject any sale of rights. They're not really rejecting the sale of rights, they're rejecting the filing.
Sale of rights bonding?
You see
Yes,
my
sure.
point.
Well,
Elliot sold his rights and he's gone, but the owner doesn't want to disclose the sale price.
right,
But we're not therefore rejecting the sale of rights, because the sale of rights has happened. We're rejecting the filing of it.
well, the question is, does it deregulate the unit?
Is it a sale, is the sale of rights even if we have not rejected it? I mean, if we have not accepted it?
Yes, it is. There's case law on that. The name is Gorga's daughter. People cite it all the time, where the court said that the sale is effective at the time the sale takes place, but I think it still has to be a sale. The issue is whether or not it's really a sale.
What's the, I was just curious, what is
Gorga's daughter. Yeah,
It's a
Scandinavian, yeah, sure.
yeah,
That was a great question.
yeah. It was an interesting case. I can send it to you if you want to read it. So basically what the court said there was that we couldn't graft on an additional requirement to make the sale effective. So the sale is effective as of the date that it takes place, but I think you don't necessarily get to that if it's not a sale. What we're trying to figure out here is, was this really a sale? So, and that involves, an arm's length transaction, a knowing waiver of your rights. I mean, we have a lot of cases on that, including appellate division cases that talk about that. And Judge Edmead, in her decision in 99 Sutton, actually mentions some of those cases. So,
Maybe it's staff must reject any purported sale of rights.
yeah, I think that's a good way of saying it. I'm not sure that will survive the plain language police, as you like to say, but we'll write it in there.
What's the
The
simple
law
word?
court must reject any purported sale of rights.
What's the simple word for purported?
Possible?
Alleged.
Well,
Reported.
alleged and purported are, to me, kind of like on the same level, but we'll see what the law department comes up with.
In the plain English, please.
Yeah.
That's within the dictionary.
I have a question on lines 23 and 24.
Okay.
The question is about authorized on line 23, the owner or its authorized.
Yes, I
And
agree.
on 24, it's his or her,
Claimed.
which should we use?
Its.
And on line 24, should there be a comma after her or another or an authorized representative? And anyway, who's the authorized representative? Like that.
Elliot, slow down.
Are you an English teacher? So could you start, could you go, you got,
Yeah, I think
Well, for
so.
one instance, the first instance is the word its is used instead of his or her.
Right.
Okay. In the second instance, it says his or her, or
It says
her,
occupant and
his
his
or
or
her
her.
authorized representative. It means it had to come directly from either he or she. Can it also be and an authorized representative? That's the question.
so tell me what's wrong first. With line 23, you said it's is not there, should not be there, the owner or its?
Well, I mean,
it could be his
call
or
the
her.
owner, it's like using the term them for, instead of he or she. These
Well, in the
days.
case of the owner, it could be an LLC or a corporation as opposed to
Well-
a gendered person.
Right. So, yeah, go ahead.
Yeah, I mean, the
That's true,
rules,
it's
the rules
authorized.
pretty much consistently refer to use an it pronoun in referring to owners because they can be
All right, I'll look at them.
non-human entities, and we did have this discussion. Whereas occupants are people, so, we don't really have
The thing
corporate
is that, let's
occupants.
say that.
But we could just say it's, I'm
Let's say
fine with
that
using it's
Pentagon wants
twice.
to sell for cloth, and we have to authorize Chuck. We can authorize Chuck to take our place in the sale, to be the spokesperson.
Why not? Why couldn't you do that?
All right, is that what this is saying?
Yeah. You don't have to be there in person. I mean, you could have an authorized representative, you could have an attorney come in for you.
Well, that's the point I'm saying, can it be an authorized?
Generally, when we
Person.
see STIPs, it's both the applicant and the applicant's attorney.
Attorney, yeah. Signed by the owner or its authorized
That would be
representative,
clearer.
applicant. So you want and? Well, I think we have, and the occupant and its authorized representative, if any.
Okay.
I mean, I think,
Because it could be an estate.
it could be.
And is,
So if it's an authorized representative,
If any.
then it could be the estate.
Okay. Well, and the occupant's authorized representative, right?
and you have to put occupant in there a second
Well, if it's an
time.
estate, you'd only have
No, you-
the authorized representative.
And perhaps children.
Well, yeah, wouldn't it be or, an occupant, or an
Well, that's what I'm
authorized
saying.
That's one of the points he's raising. We can make it or. I'm okay with making it or, as long as the representation is clear.
So it's going to be and the occupant or,
And the occupant or
An authorized
an
representative.
authorized representative. I still say we should put occupant in again. Or an occupant's authorized representative, if any.
Why do you need to put if any?
Because they may not have.
Oh, so.
Oh, you don't need if any, if you make it in or, you don't need if any. So can we make it,
how many people does it take to write a sentence?
it's important to get it right.
Six.
Okay, so the loft board's approved form must be signed by the owner or its authorized representative and the occupant or an occupant's authorized representative who sold rights to the unit. The occupant must be residing at the unit at the time of the sale. So I think this was made clear. We're codifying what Judge Edney wrote in her decision. And sales occurring after an occupant has vacated the unit are invalid. I don't know that we necessarily still need that, but if we want to make it clear, I think in terms of transparency, I think it's good to have it in there.
Yeah.
However, in the case of an estate, the occupant would not be residing in the unit.
That is true.
Say it again. I'm sorry, I missed it.
No, the occupant still, I mean, not physically, but in the case of the death, the occupant.
So we could say unless the occupant has died. Right, or,
I don't think you,
So, I'm sorry.
the
Just say
occupant
it.
is living?
well, at what
This is getting
time,
really
at what
bad.
point does the...
You're talking about that sentence that says the occupant must be residing at the unit at the time of sale?
Right.
Yeah, and you're saying unless the person's dead,
Unless the owner is effectuating the sale with an estate.
estate.
Right,
So the occupant, except,
except for
Except
sales
for, yeah.
between owners and estates, right?
Okay. Maybe that's the start of the sentence.
Yeah.
Yeah.
between an owner, right? Owners?
Between,
Owners?
well, I guess it should be an
Because-
owner
yes.
and an estate,
Yeah.
an estate representative. The occupant must be residing in the unit at the time of the sale. Sales occurring after an occupant's vacated the unit are invalid. Okay.
Okay.
So then we had a question about whether or not, and this is where we left off last time, So I had deleted the next two sentences, and I think it was Mr. Carver said we should keep the first sentence. If the occupant refuses to sign the form, the owner or its authorized representative must file with the form a sworn statement identifying the occupant, the reasons given by such occupant for refusing to exercise the form, and proof of the sale of rights, including supporting documentation. So, I think Mr. Carver had said we should keep that. I think there was opposition to that. So, I could see a situation where somebody doesn't want to sign the form, but I think the answer to that was, well, then they don't get the money, so they better sign the form. I don't know. So, what would you like to do?
Well, it would seem that, I'm fine with taking it out, but if you want to leave the first sentence in, then the second sentence that outlines what the owner has to do to back up that allegation should probably be in as well.
Are they two different circumstances?
Oh, in terms of the prior action.
Right, I think the second sentence, I think was there to encompass the situation of sales that occurred before the rules were drafted. So I know that there are early cases, I've read them, where the board had not yet drafted the rules regarding sales of rights, but sales were still taking place. So I think that that second sentence was included to encompass that, but if we're requiring the occupant to be a resident at the time of the sale, there's no reason why anybody should be reaching out to a prior occupant now. Right? So I think that that's an anachronism, and it shouldn't be there. Now, if you want to say, must provide a description of the reason, well, why do they have to be locating them? They're there. Right? So I think the second sentence can go, and the first sentence is a policy issue for you guys to decide. So just let me know what you want to do. But I think the second sentence should go regardless, because...
I think they should both go.
Yeah.
I agree.
I agree. I think it sort of muddies the whole situation.
Everybody okay with it? Okay, so. Next. Okay, so they're both fine. All right, so filing requirements on page 193. Filing requirements for sales which occur prior to the effective date of the rules. So again, we are just adding 281.5 and 281.6 that became subject to Article 7C. We're going to give, as we did with the earlier amendments, we're going to give them 90 days from the calendar days. 90 calendar days. Should be 90 days. Sorry. On page 29, let's cross out the word calendar, because we have a separate rule that says days is calendar days unless it says otherwise. On or before, whatever the date, 90 days following the effective date of this section.
So you're taking our calendar from line 5.
Is calendar in line 5 too? Yes, it should be out of there.
Where's the next one?
Line 29.
I'll have to do a global search for calendar days. I know there's one place where we actually have business days, but that should stay because we wanted business days. Okay. So the rest of it,
Now, just in terms of filing deadline,
yeah.
if they don't meet that deadline, then they're subject to it, and file it later, we'll still take it if it's valid, but they're subject to
To a fine, yes. The Thorgus Otter case, right? It's still a sale, but we can fine them if they don't file it.
Yeah.
Okay, so that brings us to page 194. There's no changes to the rest of the rule, 210, so now we have 211.1B, which is the penalty schedule. So we made some additional changes to it based on the new law. We had had very limited changes under the old document, but here we have the new document. So one of the things that I did was I took out the references to Class C penalties and Class B penalties and Class A penalties. I'm not a housing court attorney. I assume it has something to do with that, and I know HPD categorizes the violations that way. So, I don't know, to me they're meaningless things. I don't know if they mean, and I don't know that they add anything. There are penalties, they're not HPD penalties. To the extent that it might provide guidance in the housing court, maybe we should delete those. I don't know.
You'll be able to find out,
Yeah, next week we should. My new deputy general counsel should know.
Why don't we leave this as
Okay,
open?
so we can leave that as open. Okay, so then on page 195, wherever we had maximum penalties that were $17,500, we raised those to $25,000 because that's what the amendments did. So these two particular fines are failure to take reasonable and necessary action to obtain final certificate of occupancy and failure to take reasonable and necessary action to timely clear DOB objections for the owner's alteration application. So that's $1,000 per day up to $25,000. Nothing else on that page.
I'm sorry, on page 195,
Yes.
unless I'm missing something, it would appear the heading of the table is on the prior page, but I don't see the difference between, or what are we teasing apart in the first two?
In the first two,
Sorry to read the compliance deadline. A1, and the second one is A8.
right, there are two different sections of the
Right.
law.
And what's the distinction which makes one 1,000 and the other 5,000?
Hold on, I will tell you.
One of those two sections are law, right?
Just give me a second. Okay, 201, A1 are the code compliance timetables for buildings in which all residential units are as of right. And A8 is, it looks like it's 281.5. Notwithstanding the provisions of A1 through 7, the owner of an IMD does not comply with the requirements of MDL 284.1. Yes, okay. By June 21st, 2010, must file an alteration application by blah, blah, blah. So I would assume that historically, the amount of money that could be charged changed, and that's why.
Well, at this point in time,
But
if you violate the code complaint, do we really, that distinction at this point would seem kind of arbitrary.
I don't know, I would have to do some research on it. You know, that was there already, so I really wasn't focusing on what was already there, but we can do some research on it and see what the distinction is, and perhaps figure out why it was done that way. But my guess is it had to do with what penalties could be imposed at certain times, because I know the law department's very sensitive on that, and they'll have carve-outs. So it could be that that's the reason.
And they'll what?
They'll have carve-outs, they'll say
Carve-outs.
this applies to this, and this, but it doesn't apply to that.
Well, it would seem to me that at this point in time, particularly if you're an older building and you're violating the timetable, the penalty should be the same.
The same as the other one.
Yeah. I mean, and particularly, if anything, if you're, and as you pointed out, we still have more buildings in our jurisdiction that are from
281, 1 and 4.
281, 1 and 4, so to say, oh, you violate the timetable, it's $1,000, but the newer people, it's $5,000,
Yeah.
that seems
Yeah,
permitted.
So you want to raise, so you would want to raise the top line, sorry, the top line to 5,000?
Uh,
I agree with that.
Yeah, or raise it both to 10,000.
I was gonna say.
Chuck,
I'm just saying.
All right, so we will propose that.
so why do you think we couldn't change that?
I don't know the historical reason for the difference, and I'm wondering whether or not there was a legal reason why it wasn't changed. You know, you would have thought, right, and I've done a lot of stuff with penalty schedules, as you know, so you would have thought if you were adding something that would make it a $5,000 penalty at a later date in time, you would have made the earlier one $5,000 also, but they didn't.
Oh, so that's what you want to
So I want to
research
see if there was a legal reason why that didn't
Or
happen.
we just missed it.
Or that could be too.
And
So
I
we
would-
can propose to raise that to
And
5,000.
I would assume, since the second and third table entries have a capital B in buildings, we'd probably make the first one a capital B as well.
Yes,
Helene,
yes.
fail to take reasonable and necessary actions to it.
Mhm.
I know we have the maximum, I guess, 25 days, I suppose.
Yeah,
Is there
Yes.
anything that prevents the loft board from starting another order, imposing after 25 days, like say, I mean, what is the, like each order cannot go more than 25,000, I suppose, right?
right.
So if on the 26th day, you don't have any, then can we start another?
So if you read 201.1, it tells you when we can and can't.
Oh,
So some of the failure to take reasonable and necessary action violations require trials and some of them don't. So that's all actually laid out in 2-01.1
okay.
for when we can and when we can't. So-
Like DOD has this legal conversion thing where,
Right.
so it's not like that.
Some of it is similar, but some of it is not. So, I don't remember, I can review the rule right now and tell you.
No.
But there are a couple of ones in that rule where it says we can't start another action for X amount of time.
Okay,
But I don't remember which one it is.
sure. But assuming there's none, or we can start.
Assuming that there is not, yes, on the
Excellent.
26th day, we could issue a violation. Yes, another
We got a
violation.
question over here.
Yes.
I know, I was just wondering what we do at 281.6 with fines. Do we add
A line item.
a line for, with 281.5, or do we, is this our chance to charge more?
So you want to add another one?
Well, at the moment, it would look
Yeah.
like we don't have a fine for 281.
That's true. I agree
Oh,
with
there
that.
isn't anything in between 1 and
So, yes, let's add a 281.6,
2, 3, 4, 5.
a line with 281.6.
Or
Then I
we
have
can-
to check the cross-reference.
Unless there's something there, that there's a reasoning in your research, right? We could just have one and such.
That's true, we could just make it failure to meet the code compliance deadlines.
And then you fill in.
For 1, 4, 5, and 6.
Right.
Yeah, for all of them,
Because
yeah.
that's actually.
Unless you find
That's
something.
right, so 281, 1.6.
Yeah.
Different section.
You
I
just-
do agree, there's a reason maybe the guys from the one should be fined more.
Yeah, well,
It's more egregious, yeah?
right.
Yeah, so I guess we'll find out.
All right, so we'll do the research about the $1,000. And depending on how that goes, we'll either shorten this to a failure to meet code compliance deadlines, right, and cite all of the sections of 29 RCNY, and 29 RCNY 2-01, or we'll add something for 2816, which will be the same as up to $5,000 per missed deadline.
I
Yes.
don't know why you would have any problem raising it $5,000. I mean, when it went from $50 to $1,000, there was certainly no question that the original
Yeah.
law was 50.
Right.
Right, so,
Yeah, again,
right.
I agree with you, I don't think it's a
Okay.
problem, but I just want a chance to
Okay.
look and make sure. Okay. All right, so that's those penalties. So then, the next changes are on the bottom of 196. And these are failure to renew the IMD registration pursuant to 29 RCMR 2-05. This was something that Chuck had mentioned last time.
Yes.
So I think they're not the exact amounts that you wanted, but we would be raising it to $7,500 for 1 year, $15,000 for 2 years, and $25,000 for 3 or more. That's up from $5,000, $10,000, and $17,500. So,
Yeah. Can we
Yeah.
go back to the harassment? Did you look at the fines up on the top part of page 196 with regard to harassment applications? And give any thought to whether those numbers were?
I did not.
Which one is that? Top of 197?
On the top of 196.
196.
Full chart,
Oh,
you want to revisit the numbers there too.
So a harassment application filed in bad faith is now up to $4,000.
is it up to, or that's what
It
it says?
says up to $4,000, so it's
Oh,
a
I
range,
see.
so it would be 0
It
to
had originally
4,000.
been 1,000.
But we didn't change, this has been.
This is
it
not changed, we're
since
not
when?
proposing to change this.
It was changed maybe 10 years ago to 1,000.
Okay, in that last, 2010,
Whenever we last did fine, looked at fines. There was
Hard
some
to
time.
realize it's 10 years, it's hard to realize it's 10 years already.
Yeah,
Yeah.
it is. So what are you proposing?
My question to you was, did you look at them?
Did
No.
not.
You did
No.
not.
So I tell you, this seems like a false filing. Is it similar?
The first one is a false, is
The first
one.
like a false filing. The others are, because that's a tenant saying I'm being harassed, and they're doing that in bed. And the tenant isn't actually being harassed, so it's a disincentive for tenants to just file harassment. It has to be bad. That's the first one. The other two are actually, they would be fines against owners or prime lessees.
So the first one is against the owner, the tenant?
Yes. Yes. So a tenant would file a harassment application, the owner would come back saying, I have leaks, the elevator's not working, blah, blah, blah. The owner would answer saying, no, they're not. All of this is not true, and I want a fine imposed. And so then it would go to oath, and there would be a trial. So we could theoretically fine the tenant.
Yeah.
That's the first one. The other two, as I said, are against owners of prime lessees who are harassing their tenants.
So when you say in the second one, then 3,000 to 6,000 for each occurrence,
Mhm.
is that the board's discretion?
Yes.
So why the discretion?
Well, I think it probably depends on how bad it is. So, you know, let's say,
I'm all in favor for like when we find a violation, we just have a penalty for it.
I think that's worse, you could have multiple violations covering the same, like the burst pipe or something.
I'm gonna ask you to speak up a little bit. Because I'm really close and I'm having trouble hearing.
That you could also think of it as, I could go either, this isn't an opinion so much as a suggestion. So if there were a single penalty, but you had something that where and one incident could be covered by multiple harassments or conditions.
Would we do that though? Or would you do separate?
So if you wanted to have it so that
Like you can have a
the worse the violation, or the more egregious the lack of maintenance, you would, an owner could still rack up fees.
Yeah, is
penalties.
it per tenant, per IMD unit tenant, or is it, I mean, you could
No,
have
that's what she's
10
saying.
people together and then all being harassed in one big
Yeah,
building.
Well, so if you have say a broken pipe,
Right.
then, and,
Oh, I see.
And well, I think there's a difference between a broken pipe that isn't supplying water.
it says
and a
housing,
no,
it says
no, no,
housing,
no,
right, well, that's where
right,
I'm going.
and a broken pipe that perhaps is not supplying heat. Now, having heat is very, very
Or
important,
leaking
but
water.
having water
It's more so.
is more important, right? So, you know, you have no water or you have no hot water.
So in those,
There's a difference.
So in that case, if they both occur, for example, you'd have two separate finding of harassment.
You could, yes.
Right. So that would be the board's call on how you proceed.
I assume that the oath judges, I mean, we really haven't had any harassment cases that came to the board
Yeah.
while I've been here.
I got you.
We have alluded to them.
You almost had one.
Huh? What?
You almost had one.
We almost had one. Well, we've had other cases that involved harassment findings, like the rent regulation, right, where there was a sale during the pending harassment finding. So I'm not that familiar with how the penalties work, but I assume that the oath, ALJ makes in their report and recommendation, makes a recommendation for the penalty. And then the board decides it's too much, it's not enough, et cetera. So this gives the board some discretion. I think given that all of our buildings are unique, maybe we want to have some discretion. So I know I've always been big on flat penalties because it's fair, right? But in the loft world, I'm not sure that works as well. But if that's what the board wants, I'm okay with it.
In the case of, I always have to stop and think who's closer to that. In the case of 13 East 17th Street,
Correct.
the tenants alleged 3 or 4 grounds for harassment.
Right.
The board found 2 to be harassment and found 1 that I know of, because I remember the issue, which was the owner failed to maintain the front door lock. And somebody in another building a block away was severely beaten by, somebody lurking in the vestibule. So the number of I think I don't know if occurrence here means, well, you're harassed by not fixing leaks and not fixing the door, or you're harassed by not fixing the door 6 times. So I guess what I would ask is maybe if you could take a look at this and come back and treat it as an open question for the moment, so we can be a little clearer on what we are doing.
So you want to know what you think the phrase "for each occurrence" means? Is that,
I think
you
that
want to
would,
flush that out?
yeah.
Okay.
Well, that's similar to where I was going with my comment, which is if you had a flat fee, but then you could understand that a broken pipe could be the damage to the floor plus the pipe, plus the lack of hot water, plus the sanitary, hazardous sanitary condition, and then you have four, like, so the more egregious the problem, the larger the number of violations it would cover.
So you have to understand that this is a harassment, right? What the board is finding here is harassment.
Right.
That's separate and apart from the things that constitute the harassment. So we have, under the housing maintenance rule, we have a separate penalty schedule, right? So you're not providing heat, you could be charged X amount of dollars for not providing heat. You're not providing carbon monoxide detectors, you can be charged X amount of that, money for that, window guards, et cetera, right? So theoretically, I would assume that there were already violations issued under 2-04, right, for the underlying, but it's that the aggregate together constitutes harassment, because there's so much going on. I mean, if you look at the 13 East 17th, right, like how many different things, there were like 5 or 6 different things. The elevator was working, not working, the roof was leaking, it wasn't leaking, so I think that this is separate and apart, it's over that. Right?
Part of this, and I haven't looked at the harassment rule that frequently, unfortunately, we don't have that many cases in front of us. Originally, you had the applicant, the tenant alleging harassment had to file in numbered paragraphs what constituted each act of harassment. And I think we modified that somewhat, but I just think, I mean, as we all know, there are times when owners don't do things because the fines are acceptable within the sense of that's the cost of doing business. You know, the number of sanitation violations my owner racks up is just, it's ludicrous. You know, it's like 200 a year.
Wow.
Yeah, he just doesn't care. You know, it's he just seems to accept that. But at the same time, you know, we're all remember the unfortunate architect who got clocked by that piece of terracotta. I mean, so in my opinion, things like refusal to make repairs or hazardous violations, the numbers should be
higher.
They should be serious, and I don't know if 3,000 to 6,000 is. You know, I just ask you to take a look at it.
Okay. On the class ones, on the DOB class ones, are they higher? They're 5? Yeah, so we can, yeah, I mean, so DOB has like class 1, class 2, class 3, so we could perhaps model that.
But they also have aggravated.
Well, this has aggravated too.
Oh, well, aggravated is much higher.
I also don't understand why there's harassment for safety, harassment for quality of life, and there's just $1,000 difference. Like what? I don't understand who evaluated that.
A long time ago.
I guess the idea was that the safety violations are more important.
The last time we
$1,000.
did this, and I can't tell you exactly when it was, but at that point, Elliot, I'm sure you were there, the other board members at that time got very interested in the numbers. And it was like, you know, in a way that seemed like kind of weird.
All right, so we'll look at that, we'll see what DOB does, and we'll come back to you with something, and we'll try and figure out what for each occurrence means. But,
Thank you.
You know, my guess is it's flushed out in case law. Okay. All right, so then,
Can I ask you though?
yes,
Even if it were flushed, it was flushed out in case law.
Right.
Couldn't the rules be changed?
of course they can be changed, but you need to figure out, do you need to change it, right? So you don't know the definition of the term, let's figure out what the definition is, and then we can decide do we need to change it. Because if it's a good definition, and it's a term that's been construed a lot in cases, you don't necessarily want to change it, because then people have a conception of what it means.
Okay.
So,
Yeah. And I guess finally on this point, if a finding of harassment can lead to a penalty of 3,000 to 6,000, then aggravated harassment by somebody who's done it previously it would seem to me it should be more than 10,000.
Yeah, we could make that 25,
Yeah.
because it's up to anyway, so
Yeah.
is the board okay with that? Making the aggregates up to 25?
Yeah, it's the fifth time Chuck has filed a harassment application against his hapless landlord. I would think.
Sure you don't come
Okay,
What
all
about
right.
the first one, though? Like that?
uh, From 4,000?
10,000?
The aggravated for bad faith?
Yeah, 25,000, up to, remember, it's up to.
And all
All of them are going to go up to.
I think we should do all of them.
Just say up to. The up to just
Yeah.
means that's the maximum of the thing.
Right.
It doesn't mean that's what you're going to do. The board has said something, but
Right.
it's just, because it's aggravated, the board should have some discretion in going to a maximum to effectuate.
So you have to file 6 bad faith harassment.
Well, you know.
Hopefully you'd learn by
I
that.
will also say that the penalty on the first line for the harassment application filed in bad faith, if we were going to treat that as like somebody who did a false filing, I am proposing raising another penalty for false filing to $5,000, because that's what DOB charges for false filings. So the board should consider raising this one to $5,000
Sure.
also.
Which one?
The first one.
Harassment, right?
Yeah, the harassment filed in bad faith,
So they'll match. That
so
makes
they'll all
sense.
match, yeah.
Yeah.
Okay, so we'll make that one 5,000, okay. Okay, so, moving to the bottom, which is sort of where we started, we went back up top. So the proposal for the failure to timely renew the registration is to raise the first year from 5,000 to 7,500, the second year from 10,000 to 15,000, and 3 or more years from 75 to 25,000. Is the board okay with that?
Can you explain what the terms are for that? Because I think you said last time, August was due, but September you got all, like, do you have a 30-day window?
Yeah, you have they're supposed to pay by January 30th, by, I was getting my J months confused, sorry, July 1st. July 1st is when they're supposed, they have up to July 1st to pay. Then they have a 30-day grace period, and we don't start charging the late charges until August. And the late charges look back. So you didn't pay for July, $25. You didn't pay for August, another $5. Excuse me, per unit. That's separate and apart from this. This is when we bring the FO cases like we did in December. So this is over and above the registration fees and the late fees. This is a penalty that's charged, a fine, because you didn't get your act together. And what Mr. Delaney was arguing for was that we should start that process earlier, and we agreed that we would do that. So we would try and bring those to the board earlier.
Because the staff spending time will show up and turn it in just before.
Right.
Right.
I think the phrase you used was an interest fee loan.
Well, I once had a very interesting conversation with a realtor upstate who held a lot of properties that
I just want to get it.
Yeah.
Yeah.
that he would buy on the cheap and hold with the hope of reselling. And he told me he always paid the property taxes at the last minute and took the penalty. So if it's like 1% if you're 60 days late and 2% or whatever if you're 90 days late, he'd always pay 90 days late. He was viewed as a low interest loan. So in the same way, we had that one FO owner who had either 2 or 3 properties, seemed like a pretty savvy real estate outfit, who showed up at the last minute, thereby escaping the significant fine and paying what's really chump change in penalties. And to me, that's just working the system. It's not giving us the registration information. So I have made the argument that I think the late fees should be more significant so that it's not as simple a calculation.
So we are exploring
Yeah.
But as I said, fees are different from fines.
Right.
And fees really are looked at very closely, because we're government and we're not.
It's because they're taxes.
True.
We're government, we're not supposed to pay
When
tax.
you get right down to it.
The fee should be, the amount that,
Yeah, that's a justification
Right.
for that. So it's just.
The mayor don't want to hear about no tax increases.
That's your words.
okay.
So,
So
yeah, so
we're
these
good
numbers
with,
are
so we're
good?
good with these numbers? The 7,500, the 15,000, and 25,000. Okay. So then on the next page, the board had agreed that.
I'm sorry,
Yeah.
and then before you go, I wanted to talk, I asked about this cure thing, what it means again. Is it defined anywhere?
Yes,
Okay, it is.
it is. It's defined in the underlying rules,
Oh, I see, okay.
right? Like, just like in DOB, right?
Sure. So a cure is the fact, I was looking at definitions, I didn't see it. So it's in,
If you go to, like, if you go to 202C2 III, or, well, actually, that wouldn't be a cure. So if you go to 29 RCMY 2-05F2, that'll show you, because it says cure yes, that they can.
that they can cure.
Yeah.
And the cure itself would be defined there, the word cure, yeah, okay, good.
Yeah. Okay, so on 197, we are changing the monthly reports to quarterly or requested reports. God bless you.
Bless you.
So we're changing the language in the penalties to indicate that they will be quarterly or requested reports. And again, the table on page 198. So we're just changing the monthly to quarterly or requested. And here's the false statement. So it was 4,000, we're changing it to 5,000. We're asking to change it to 5,000 to be in sync with DOB. That's what DOB charges for false filings. So any,
I just have a question about the term. Is that normal to say requested versus quarterly, I guess, instead of monthly? But then when you say requested.
so when we discussed the amendment to that rule,
Yeah.
that was the language that the board came up with, because we wanted to make sure that staff could request additional reports. So if we're going to require the reports, the legalization reports quarterly, so let's say somebody filed a report in January and it's the middle of March, and they're asking for a loan note. So one of the things that we look at when we're considering loan notes is, are they making progress on a legalization? Because we don't want them working just in the commercial spaces and not in the residential spaces. So it's possible that we might want to say to them, well, file your next report now so we can see whether or not you've made progress. So that would be a requested
Are we going to
report.
fine them for it if they don't provide it, or just deny it?
No, if they file a false statement, and we
Yeah.
would fine them.
Yeah.
I would hope we would.
So it's the quarterly or when or any report that we requested. I got
Right.
you, I got you.
This is
So I got
if
you.
they file a false statement in a quarterly or a report that they requested, yes. So that's how we phrased it.
I
That's
wouldn't
all.
like proactively just request a report out of the blue. It's because they want to do work.
Yeah.
It's because we feel we need it for something.
Right.
Yeah, I mean, we're not, there's
And
no
if they're
reason.
going to file it, they must file it.
We have enough paper. We don't need more paper. So no, we're not asking for more reports.
Yeah.
But there may be a reason that we would want one, and we should be able to do that. Okay, so that's that one. So then on page 199,
Before you go there, I think on page 197, you got the word Class C at the top there.
well, we're gonna leave that open. We're
Oh,
gonna
I see.
figure out whether or not we really want those there, want or need those there.
The word Class C.
Yeah, Class C, Class B, they're all over
Oh,
for
I
each
see.
one.
I see.
So we'll figure out. Okay, so then on the top of 199, on line 5, for whatever reason, the word may is capitalized. It shouldn't be, so I made it lowercase. And I'm not proposing changes to any of the other penalties in that section. If the board wants to raise them, let me know. I don't know why the failure to post the IMD notice shouldn't be curable.
Why would the cure be posted?
Posting the notice, yeah, I mean, wouldn't we want them to post the notice?
Exactly.
Is the curability in our rules, or is it just in the schedule of fines?
It should be in the rules.
So by cure here, you mean that if they fix it, they would face the penalty?
Yeah, I guess that makes sense, right, too.
Maybe.
I don't know.
No, right, so
So I would
the
want
reason that
Right.
it's a no is because then, right,
Yeah,
Right, we want to charge them for not putting the sign
Yeah,
up.
this should be no cure.
Okay,
on line 4,
line 4, yes.
I don't think you need that comma at the end.
Yes, I agree.
You're
199.
still on 199.
Mr. Morrison, I think.
Yes,
Which is probably why that may ended up campus and how it.
Maybe, yeah.
Maybe there was another word in there.
or something was changed. I don't know. Okay, so then on the bottom of the page, on 190, on the bottom of 199, starting on line 8, these are new penalties for sections that we added, proposed sections that we will be adding. So these are fines in connection with violating a loft board order or filing a false statement with the loft board pursuant to 1-115. So this would be a false statement that's different from 1 1/4 report, okay? Because people file all kinds of things with us. So the introductory language follows all of the other introductory language. Any person who is found to have violated a loft board order pursuant to 1-13B or to have filed a document containing a material false statement pursuant to 1-15D as in David may be subject to a civil penalty as follows. And again, they're false statements, so $5,000.
So the violation of the order is this, is not,
It's $5,000.
so, so these are guided by the 25 max also?
Yes.
Okay, so this applies to anyone?
Yeah.
Owner or tenant?
Yes.
Should we break that out?
No, it says any person who's probably violated a law.
Yeah, no, I'm just saying,
order.
I got you, but I'm saying, should we break out the penalty and make it different for a tenant versus an owner? I would want to do that, only because I don't think, that the
Tenants may be in an inferior financial position.
Correct.
Is that
Are you talking with different fines or the same fine?
different funds?
Right, I would like to break that out. I don't know what you guys feel about that, but just two separate charges, with two separate penalties. Same section.
So what is your proposed?
So like violation of a violation of a loft board order tenant, violation of loft board order owner.
And so what are your figures
That's
for either?
5 and 75.
What's an
That-
example of a
that's my-
tenant?
Well,
or
I don't
Access.
know. I don't know.
I don't
Access,
disagree
not
with
letting
that, but I think
access to
that's
the person.
discriminatory.
They
It
could
isn't.
have to pay
Huh?
$5.
It isn't, no?
No,
Not if it's in the rule.
Yes.
Well,
It is?
If the loft board
But if it's in the
orders
rule,
it,
it will be
they don't
discriminatory.
apply.
It is in the rule.
No, not if you put it in the rule, it wouldn't be discriminatory. No, I just think it's more, you will find that it would be more egregious to me, I guess you guys could chime in, but if an owner violates a loft board order and is probably more in the position to have more effect on more people than when a tenant violates a loft board order of some sort.
I don't disagree with that. The owner is an entity,
No?
an
Well,
individual
not necessarily.
person. one person.
Just to put on a Mr. Carter hat for a minute, okay?
Where is it?
He would be upset about that.
I assume he would be. So, first of all, I think an argument would be made, and I'm not saying it's right or wrong, that not all owners are fabulously rich, okay? You do have some small building owners and small buildings, and it's difficult for them. So that's one argument. Sometimes the tenants aren't paying them rent, that's another argument.
But sometimes.
I still don't think that's an excuse for violating the law court order, but in terms of having a tenant holding up other people, you theoretically could, because if you have a tenant that isn't providing access and the owner needs that access to do the legalization work, then that owner's not going to be able to complete the legalization work, and the owner's not going to be able to get a C of O. So I think that's how the argument would run.
The tenant can define, like if the tenant has a job that starts at 7 a.m. or something, I mean,
But that would be, yeah, I
Well,
hear you.
I think
I mean, I wouldn't want them to be-
I think it's reasonable, and tenants, the rule allows tenants to give their keys to other tenants and tell the owner, go knock on Joe's door if you need to get into my unit for this. So they set that up. I mean, most tenants, I think, don't really deny access, and, and it is an evictionable offense also.
Right.
So, there's a lot of serious consequences, but if you're gonna say, well, it's just one tenant, it's not affecting other people, it really could. What if you need to turn the gas back on for everybody in the line and you can't do it because the one person isn't there?
Well, that's why I'm not changing the number. I'm changing the number because I think the landlord is more, if the landlord's action in violating the order of the board would or could affect more people, more, I just think.
I mean, if that's what you want to
If
do,
we
we can
do
put it in,
that-
we'll see what the law department
If
says.
we do that, I think
Yeah.
it would be fair to look at some way to say that the board would have the flexibility of up to that board on that you're proposing.
You mean,
So
so
that
up
would be-
to here? instead-
Well, whatever number you're proposing is raised to, I think we should go with up to.
It's similar to what you have over on the other side.
Because there may be cases where we would find that,
Yeah.
Okay.
If
It's not necessarily.
Okay, so we would say up for, if we split this,
I'd be more in favor of doing the up to and leaving it to
Yeah, I
discretion.
think that's a good idea. See, if the tenant, because I'm not necessarily the tenant, is ignorant of the law that says, oh, you can't violate my apartment, my loft, you can't come in. And then we say, well, too bad, you get fined $1,000. Well, I don't know whether that's.
But except in the in-between, in the interim, there's the order. So that the tenant's not
Yeah,
letting
the
the
tenant should
landlord
be aware of
in.
that.
The landlord
You're right.
comes to us, we issue a written statement that says you are ordered to let him in. So,
And you have 30 days.
and you have 30 days to do so.
Before you-
Right?
All right, I mean, the tenant could still say, well, you're
No, there's no
violating
cure.
my personal space.
there's no cure.
No.
I mean, who are you to do
No
that?
cure.
Because this is after they've just refused the order, so there's no
It's
And-
point.
interesting because I'm working on
It's the-
private work where neighbors aren't giving us access and tenants aren't giving us access. And everyone I've talked to, from architects to structural engineers to third party, they're like, this happens.
All the time.
Well,
So-
that's part of the issue in that terracotta case, where the
So-
landlord claimed that the neighboring building owner
Oh,
would.
you wouldn't let
Right.
them
The
do
one
the
that, the
work?
one
Right.
that killed the architect?
Yeah,
Uh-huh.
So because they're in the law course jurisdiction, we just have another view of it and we fine 5,000. Whereas if they were just tenants and they weren't giving access.
Well, I mean, they would go to house. I assume the owner would take them to house. If they weren't in the loft,
Which
world,
would
then they were
take,
residential tenants.
So-
I don't know.
So is there anybody in favor of splitting it, or just having a range or both?
I don't mind the splitting it, I just like the up to.
Up
I
to.
think the
Yeah, I
up to
think up to,
is,
because
I don't
last
think
time
we
it
should
was
split it.
I think up to is,
So,
No splitting.
I'm okay with it, just have the range then.
So you want it up to violation of a loft board order up to $7,500 per violation or something?
So you can say between 5 and 5.
Why is there no cure?
Because
Because it's after the fact.
Because after you've done it.
Right, so to give you an example, right, the loft board says to the owner, register, right, coverage is granted, owner to file a registration within 30 days, failure of the owner to file a registration will assign the IMD number. Well, the owner still has to register, right? Well, we have at least one owner who has never filed a registration.
No cure doesn't mean you don't have to do it. It just means you don't get a break
You
from
don't
that.
You don't get a
The
break from the
violation
penalty, you still have to
doesn't
do it.
disappear if you cure.
Yeah. Order is an order.
Well, you know, okay, wait, I just want to make sure I'm understanding right.
Cure
If
is
you
not cure.
speed and you get a ticket, it's a ticket.
Yeah,
If
that's a no cure.
If your car
That's a no
is
cure.
missing the registration for,
That's
they
still
might
a no
give you
cure.
like a.
Oh, yeah, break, yeah.
Right,
That's a
like
cure.
another
It's
30 days to
to
fix it.
Produce the registration.
No.
Yes, you do.
Yeah.
Okay, so we're not talking moving violations. Let's not get distracted by moving violations. Let's talk about loft board orders,
But
right?
it kind of makes people jump, like if you scare someone, like a tenant doesn't realize how serious it is, that they are not giving access, and then you give them this scary warning, you have 30.
So that's the cure.
I would do it, at some point I'd be.
But the order will say you have this time to do it, right? And within that period, you must do it. If you don't
But
do
this
it in
says
this
cure
period,
no.
right?
No, but we haven't reached the violation yet,
Yes.
because we're still within the 30 days
Oh,
of
yeah,
the order.
Right. They have, right, we don't issue the violation until they violate the order.
Yeah.
Right, so if the order says you have to provide access, and then they don't provide access, then you issue a violation for violating the loft board order. Right, so they've had a period.
They know that they're well aware
Yeah.
that they
Yeah.
got certified mail.
Yeah.
Yeah.
Yeah. And to be perfectly honest, all the access applications always settle. That's been my experience. The owners file them, they go to oath, they have a conference, they settle, and that's it.
So
So what are we changing this to?
we're just saying between 5 and 75.
$5,000
We're
up
getting a
to
range, but we're still in one
7,500?
column, right? A range, but within one column.
Yeah,
Yeah. but
$5,000 up to
And we're not
7,500.
splitting we're not splitting the violation, right? Is that what you're saying?
Correct.
Yeah.
So, okay.
So it'll be violation of a loft board order. The penalty will be $5,000 up to $7,500 per violation. Okay?
You all right with that?
yeah.
Okay, so just to quickly do 212. So these are just changes adding things for 281.6. Okay? So these are, this deals with rent adjustments for code compliance. So we're just adding the references to 281.6 and the new interim rent guidelines for 281.6, which are in 29 RCNY 2-06.3. The board actually already discussed that, the underlying section, but we're just adding those references. So that's on page 201, on line 7. 281.6 is being added on line 21, also on 201. Nothing on 202, on 203. We're adding on lines 9 and 10, the reference to 2-06.3. All right? So I think this is.
One question.
Yeah, sure.
Under the sale right.
Sure. What page?
Was that a
What
rumor
page?
that I heard, is it sale rights? Is that where we started?
191, we started this one right now.
You were saying, well, when we were talking about redacting in part, like, we don't know what, like, you said $10 might not be the right
Yeah,
value.
Well, your question.
Or security deposit, like that. But is the housing court, is there a, with rent stabilized, is there a number of a sale of rent? I thought someone said once that there was $30,000 sale rent baseline.
I don't
For
think so.
some other thing in the city, nothing. There's no.
I'm not familiar with anything else in the
Market
city.
value, there's no,
So-
like, someone could, the asking price could be $5, or it could be $1 million.
You know, my personal opinion is, there's nothing wrong with a $10 sale, as long as the tenant understands that their rights could be worth a lot more. I don't think there's anything wrong with somebody saying, you know what, I don't care, I just don't want the hassle, I don't need the money, I'm just going. I don't think there's a problem with that.
So there's no minimum.
The question is, if it's a $10 sale, does the tenant really know?
Yeah.
That's where you get into the issue.
Well, we've also talked about, so instead of redacting, sometimes the bill of sale, it does say $10.
Or usually it says $10 and other good and valuable
And other good,
consideration.
right, and so,
So you gotta wonder what
sort
that
of the
is.
assumption is the $20,000 in cash that happened that nobody saw, but only on the record is 10, which is what you were getting at about proving it and showing it.
Yeah.
Right?
I mean,
So that there's a,
when we have doubts, we regularly ask them to provide us copies of the canceled checks. I mean, we do that a lot.
I was just bringing it up, because like real estate is comparable.
Yeah.
So if you can, if it's always like this private thing. I didn't know if there was like a baseline, but.
No, I think it's going to depend on the situation. So, you know, we've seen sales, I've personally seen sales in the hundreds of dollars. I've seen a couple of sales over $1 million. So,
And someone
location.
Someone can foil that information?
Well, no, see, so if it's redacted, yeah, they'll get a copy of the redacted information.
Yeah.
If it's not redacted, we asked the law department if we could redact it, if somebody requested it, and under FOIL, there is no basis for a redaction of that information.
There's no basis.
There's no basis. So if somebody filed a document with us that said, I gave X, right, I gave Joe in Unit 3 $1 million, and Jane in Unit 4 foiled that, because the owner approached her and said, hey, I'll give you $50,000.
Right.
Jane might have a different perspective on how much money she should be countering.
Or
in her counter offer.
landlords could write $10 and extra goods or something.
Well,
And keep it.
Well, again, we would have to, in that situation, kind of figure out, well, did they just pay $10, or was there other good and valuable consideration? So, that's why, but the rule would require them to say a full description of the consideration. So they can't say $10 and other good and valuable consideration, they have to say what it is.
Right, like what, in real estate law, which I don't know anything about. All
This
these
is one of
sales,
the
you
things
could
to
like
cover.
Google whatever property you want and know exactly how much it was sold.
Well, that's because when they filed the deeds, they
Right.
have to pay transfer taxes, and you can
Right.
compute how much it was based on the transfer taxes.
That's why you see $10.
Yeah, the deeds itself, it usually says $10 and other good and valuable consideration, but if you really want to know how much it was, you can take a look at the amount of the transfer tax, and
And then
there's a
multiply by
formula,
something,
and
yeah.
multiply by whatever it is, yeah, figure it out.
but if there's, and there's still a way around it.
People will always try and find a way around it, but that doesn't mean that we can't pass a rule that will
It's
try
true,
to
it's true.
make it harder.
All right, more information, the better, I think. Open source is what I'm going for, but because it seems really murky right now.
I'm sure we will get, in the public hearing, we will get pushback about this.
So in the anticipation that we're probably about to pack it in for the day,
Yes.
what is our battle plan for the January 30th rules meeting? Where do we want to start?
So I think really the only thing that we have left, other than some minor open issues, is 209. And I think the board should be prepared to discuss 209 and make a decision. And I think if the board can't make a decision, then my opinion, and you can all think about this, is what we should do is leave it as it is except add the spouse clause. If the board just can't come to a conclusion as to what the language should be, we shouldn't hold this up anymore. It's been 2 years, we have a new law, we need to make these changes.
So the focus for the next meeting is 209.
209, yes.
And then at some point, are we going to do a quick overview of all the other?
Yes, then we should do the other open issues, yes. Hopefully we can finish 209 and do the other open issues. And maybe what we should do is set a time limit for how long we're going to discuss 209 and figure out how much time we need for the other
How
open
much time do
issues.
we need next month, that next time, later in this month, on the 30th? For
It's already been
Well,
projected from 1 to 4:30.
Right, so don't you
Right.
think that's enough time?
Yeah, no, I'm saying how much time from the 1 to 4:30 should we devote to 209? And then make sure we tie up the loopholes. I mean, one of the loopholes is the definition of, in 209 as to whether or not the prime list is the lease in effect. And I know that you were concerned about, depending on how 209 goes, whether or not you want to leave it that way or not.
Right.
So those two are kind of intertwined.
And then there are all the little bits and pieces like Class C and Class.
Yeah, but those I think are,
Class-
those I think are straightforward. So, and then the rent overcharge also we have to talk about.
Do we have the other open issues? Is there a, could
They
you send
should
us a
be,
list or?
they should be highlighted. And if they're not, I will definitely send you.
Well, in this version,
They're in
the
yellow.
track changes isn't visible.
It isn't visible, okay. Yeah,
If you
okay.
could, you know,
There's some
I'll put together a
highlights.
list.
if you could put together a
There's
list
highlights.
and circulate it.
I'll put together a list, I
that
think
would
that's,
help us.
yes, I think that's,
Is
yeah.
the goal to finish, well, of course, we
Finish.
want to just finish 100%.
Yeah, the goal, my goal, I can always dream. My goal is to walk out of here on January 30th with something that I can send to the law department to say, here are our proposed rules. Okay?
So let it be, so let it be done.
Not like circulate the
If we-
whole
if we
thing
met
for
that goal.
review.
I just did.
Oh, wait, what's it?
Okay, I mean, it says everything except the changes that we're gonna make.
If we met that goal January 30th and you sent it to the law department,
Right?
is there a window, like where do you guess it would be before it would go into the public? June?
No, to be enacted or to go to the public?
No.
Well,
It's a lot, I'm not sure how busy they are, they're always busy.
Still got to come back to us.
They have to come back to you regardless, yeah.
Yeah, you're gonna mark it up and send it back to you.
I would say at least 8 weeks of the law department.
so March 30th.
So,
Well,
I have to send it to them also, so, yeah. And then we would publish and hold public hearings, and I assume we'll need at least 2. So you need 35 days.
It's
of
gonna be the
public
summer.
hearings. Yeah, it'll be the summer.
It's the summer.
so our April meeting is probably when we're voting.
Likely
Depends
April.
on the law department and the planning.
Okay.
They're saying it's
Just for the record, it's the mayor's office of operations, and I'm a believer in plain language. I just want.
Okay.
Okay.
Claire?
If I could just say one thing.
Yeah, sure.
We're finished with the
Are there any other
Rules.
issues with rules? Okay.
Okay, so just in the interest of public safety, wanted to just get a little safety message in here. We had a very serious fire in the city within the last week, and again, we've had a situation where the fire could have been much less of an impact on the building, and the occupants had the occupant that had the fire pulled the door shut when they left. So please, close the door, close the door.
I just want to add. to
Close the
that.
door.
I learned the hard way. The building next to mine went up in a 4-alarm fire, and it's still a vacant lot. We exited, I closed the door, but I locked the door. And some robust, happy fireman was all too happy to take down that door with an axe. So the lesson is close the door, but don't lock the door, because I learned the hard way.
Well, that is the reason your door closes, it's supposed to close on its own behind you, self-closing fireproof door, yeah.
Yeah.
The whole, your front door doesn't go. Right, the self-closing door doesn't work, it's not required on the front door.
Yeah.
Well, it typically, yes, but there are some going back in time buildings that believe that is not the case.
Yeah.
Newer firewalls, newer construction, absolutely, that would be,
Right.
that would be the case. But there's a maintenance issue there as well, so we can even tack one to say that if you believe your door is supposed to be a self-closing door and it is not a self-closing door, call our friends at HPD and have them come out and take a look at it, and they can issue a violation to the owner of the building to make it a self-closing door.
Or you can call the fire department to break it down.
For the more dramatic effect.
But please take that very serious, because last year we had a very serious fire in the Bronx where that was the case. Thankfully, this fire was not as serious, but it easily could have been, and damage-wise even, and displacement of occupants, it was a very serious
This
fire.
is that east side high-rise, right?
About 70 seconds.
Yeah.
Okay, I appreciate that, Mr. Roche. On that, I just want to also congratulate him on being promoted to Deputy Chief Inspector. I think it was So this will conclude our January 16th, 2020 Loft Board meeting. Our next,
Do you need a motion first?
no. Mr.
No, you don't.
This will conclude our January 16th, 2020 Loft Board meeting, and our next public meeting will be held on Thursday, January 30th, 2020 at 1 p.m. right here at 22 Reed Street, Inspector Hall. Board members, please sign and hand in your attendance sheets. Thank you. Have a good